Hey guys, welcome back, and if you're new to our channel then welcome. Today the video is going to be the second video in the bail series. If you haven't seen our first video in the bail series, I will link it on the screen and also in the description box. Don't forget to check it out. And the video for the day is bail by high courts and court of sessions, which includes granting of bail and also cancellation of bail. So let's get on with it. Section 439 of the Code of Criminal Procedure deals with granting and cancellation of bail by high courts and court of sessions. Let's start with the granting of bail. Section 439 Clause 1 provides that high courts or the courts of sessions may grant conditional or unconditional bail to any person. However, if the person accused is triable by the court of session exclusively or is punishable with imprisonment for life, then the high court or the court of session must give notice to the public prosecutor. Let's move on to the second topic of today, which is cancellation of bail by high courts and courts of session. Now this topic is more important of the two between granting of bail and cancellation of bail. Cancellation of bail is the more important because it is more nuanced and is often asked in exams, etc. Section 439 Clause 2 provides for cancellation of bail by high courts or court of sessions. If the bail was originally granted by the magistrate, it can be cancelled by the magistrate or the high court or the court of session. If the bail was granted by the court of session, it can be cancelled by the court of session or the high court. And finally, if the bail was granted by the high court, then the high court only can cancel it. Circumstances for cancellation of bail. Cancellation of bail is absolutely different from granting of bail and requires a post-bail circumstance. For cancellation, for example, violation of some condition of the bail or some other extraneous post-bail fact. It is important to know that once bail has been granted, the courts are very circumspect in cancellation of bail, as was held in the case of Nityanand Rai versus State of Bihar, which is a 2005 Supreme Court judgment, and also in Panchanand Mishra versus Digambar Mishra, which is also a 2005 Supreme Court judgment. Cancellation of bail must be done through a speaking order, as was held in TIWARI versus State of MP, which is a 2009 Supreme Court judgment. Another thing to keep in mind is that if the accused had suppressed some fact in the pre-bail hearing and that fact comes to light after bail has been granted, then the courts can cancel the granted bail on that suppressed fact. The courts can take it into consideration and see whether the bail requires to be cancelled or not, and based on the importance of that fact. Also, if there wasn't any suppression of a fact but a new fact comes to light after granting of bail, then the courts can take it into consideration, but it has to be a new fact. The courts take a presumption that every pre-bail fact was argued by the state when opposing the bail. And now the bail has been granted, cancellation cannot be done on any pre-bail fact, so it has to be a new fact. Oops, I think I just got a little carried away. So you get the point of it. It has to be a new fact or a suppressed fact which was not known to the courts before, or violation of some condition of bail because of which the courts can cancel bail. Thus, it can be effectively concluded that cancellation is not a routine matter. The courts will take into account every aspect before cancelling bail, as was held in the case of Rizwan Akbar Hussain versus Mahmood Hussain, which is a 2007 Supreme Court judgment. All the important facts that you need to remember for granting of bail and cancellation of bail by high courts and courts of session. Next week, we'll deal with another aspect of bail in our ongoing bail series. So don't forget to hit the subscribe button so you're first to get notification when the video comes out. Leave us any requests in the comment box, and thanks for watching.